All right, well, when we were planning this conference, a number of people thought, well, why don't you just make this a climate change themed conference? And certainly we could have done that and spent a very profitable 2 days talking about nothing else. We ultimately chose to broaden our horizons somewhat, but at the same time, as I tell our students, climate change is the overarching environmental issue of our day, and it touches on water supply and energy and biodiversity and virtually every other environmental issue that we confront. So you will be hearing a great deal about climate change in one capacity or another over the next 2 days, and for the next 90 minutes you're going to hear about it explicitly. We've put together a very exciting panel to discuss climate change litigation, its potential, and its limitations in advancing climate change policy. I'm going to briefly introduce our moderator. Ken Alex is the, as of last month, the Senior Assistant Attorney General leading the California Department of Justice's energy litigation efforts statewide. He has been with the Attorney General's office for the majority of his distinguished career. He practices here in Oakland, but has a statewide and national practice. He has been at the forefront of climate change litigation on behalf of former Attorney General Bill Lockyer and now current Attorney General Jerry Brown. His accomplishments have not gone unnoticed. California Lawyer has named Ken Alex as an Attorney of the Year in connection with his work on energy litigation issues. And last year he received the ABA Award for Distinguished Achievement in Environmental Law and Policy as a result of his global warming litigation efforts. And I encourage all of you to come to the Ecology Law quarterly annual banquet tomorrow evening when Ken will appropriately be honored with another award. And Ken, take it away, and he will introduce the panel.
Oh, great. Well, thanks for being here. One thing I can say about Rick is that he's my former boss at the Attorney General's office. So if there's anything you don't like about the Attorney General's global warming litigation, I'm sure we can tie it back to Rick. This is obviously a very timely topic, and we have biked in from around the country a very distinguished panel today. And I will get to introducing them in just a minute. I want to just take a minute to introduce the idea of the panel. I think it's sort of indisputable that one side effect of global warming and greenhouse gas emissions is that there has been a renaissance in interest in environmental law. And that has resulted in virtually every major law firm in the country developing a practice involving global warming issues and having global warming groups. It has re-energized, I think, the professorial community. In fact, earlier this week, there was a 2-day seminar at the University of Chicago, 2 full days on public nuisance and global warming. I wonder where they got that particular idea and why Ted wasn't invited. And also, I'm sure that those of you who are students and are otherwise on law school campuses have seen a renewal of interest, certainly that hasn't been this level of interest in environmental law in quite some time. So I'm sure each of the panel members will thank the Attorney General's office for their litigation efforts in bringing these sort of more fun issues to the fore and creating a new area of practice. Okay, so what we're going to do this morning, I'm very briefly going to lay out some of the current and possible additional litigation that we may see in the horizon. And then our panel members are going to go through and talk about, in a critical way, whether use of courts and litigation is really appropriate. Is this a way that makes sense to deal with the various issues of climate change and global warming? And they have promised me a short rebuttal at the end. So let me introduce the panelists. To my immediate right is Theodore Boutros. a partner in the Los Angeles and Washington, D.C. offices of Gibson, Dunn & Crutcher. He's the co-chair of the firm's appellate and when I get done with this, you won't believe that he has time to be here. He's the co-chair of the firm's appellate and constitutional law group and its media and entertainment group, and vice chair of the crisis management group. Mr. Boutros has represented clients in the federal and state appellate courts throughout the nation in a wide spectrum of cases, including punitive damages, employment, class action, environmental, insurance, products liability, antitrust, business torts, securities, privacy, arbitration, criminal, and constitutional litigation. And I should add that he is so far the winning attorney in the public nuisance case that the two of us are attorneys representing parties, and I'll mention that case in a minute. He is responsible for the nationwide appellate strategy for several major companies and has successfully persuaded courts to overturn some of the largest jury verdicts in history. Mr. Boutros received his law degree summa cum laude from University of San Diego Law School, where he was valedictorian and editor-in-chief of the San Diego Law Review. Equally impressive, Professor Merrill, in the middle of the panel, is the Sidley Austin Robert D. McLean's 1970 visiting professor of law at Yale Law School, where he specializes in property, environmental law, administrative law, eminent domain, and the U.S. Supreme Court. Merrill is the Charles Keller Beckman Professor of Law at Columbia Law School. He received his BA from Grinnell College in 1971 and a BA with first-class honors in politics, philosophy, and economics in 1973 from Oxford University, where he was a Rhodes Scholar. He received his JB from the University of Chicago Law School in 1977 and went on to clerk for the Supreme Court Justice Harry A. Blockman. He has also served as Deputy Solicitor General. Professor Merrill has published dozens of articles in the country's most prestigious law reviews. And I might add that very early on, Professor Merrill had published a pretty influential article about public nuisance and climate change litigation. He has co-authored multiple textbooks generally dealing with the laws of property. And on the far end of the panel is Professor Kirsten Engel from the University of Arizona, James E. Rogers College of Law. She has a broad background in environmental law and policy that spans both academia and the public sector practice. Ms. Engel recently served as a member of the Arizona Governor Janet Napolitano's Climate Change Advisory Group and has held visiting professorships at Harvard and Vanderbilt Schools of Law. Between leaving her faculty post at Tulane Law School and joining the law faculty at the University of Arizona, Ms. Engel served as senior counsel for the Public Protection Bureau and acting chief of the Environmental Protection Division of the Massachusetts Office of the Attorney General. Prior to entering teaching, Ms. Engel worked as staff attorney for the Sierra Club Legal Defense Fund and at the U.S. Environmental Protection Agency. So they bring to bear quite a lot of expertise on the subject, and we will get to their expertise in a moment, but I want to run you through a survey of existing litigation. This is not a complete survey, but just to give you a sense of the kinds of issues that are being litigated and their current status. So, okay, so I'm sure all of you know of Massachusetts versus EPA, recent one-year-old Supreme Court decision, 5-4 decision, directing the EPA to evaluate whether it can regulate directly CO2 and other greenhouse gas emissions from mobile sources. Right now, the current status a year later is very political. The Bush administration has opened for public comment a year after the return from the Supreme Court, requesting public views on how it might consider regulation of greenhouse gases for mobile sources. There are many, many implications of Mass versus EPA, and some of those flow into number 2, which are the other Clean Air Act cases. The Attorney General's office in California and others have filed a series of petitions under the Clean Air Act various different sections of that act regulate different sources, such as stationary sources like power plants, ocean vessels. It turns out that there are 90,000 or so large-scale ocean vessels, which represent 3% of the world's emissions of greenhouse gases, which is kind of astonishing. Those are subject to regulation by EPA. Large truck engines, off-road vehicles. There are a series of different sections that use the same or similar wording to the words at issue in Mass versus EPA. Those petitions are working at some pace or another through the EPA bureaucracy, and I think most people's guess is that we won't see any action on most of those until there's a new administration in Washington. Number 3 up there is a case that was decided by the Ninth Circuit having to do with CAFE standards, the mileage standards for light trucks. The Ninth Circuit said that the National Highway Traffic Safety Administration, which administers these standards, the mileage standards, has to include in its environmental documentation consideration of greenhouse gas emissions and global warming, and evaluate different possible alternatives when considering what mileage standards are appropriate. That case is on petition for rehearing at the Ninth Circuit. So although just recently NHTSA has said, has issued a notice that they are starting their environmental review. So that is in progress, and that will no doubt go to the next administration as well. There are a series of other NEPA cases, the typical kind of environmental challenge about programmatic EIRs, excuse me, that's a Californiaism, EISs, environmental impact statements. To what level does the federal government need to look at greenhouse gas emissions and climate change as part of their environmental analysis? That's a big area of litigation. The next 2 cases, I think the panel will no doubt talk about a fair amount. California, and in the first case, 7 other states sued first a series of the largest power companies, and in the second case, the largest automakers, alleging under federal common law theory that the emissions from their sources resulted in a nuisance, public nuisance, harming California or the other states, and that either injunctive relief in the case of the power companies or monetary relief in the case of the automakers was the appropriate remedy. Each of those cases has been dismissed by the district court as a non-justiciable political question. You may hear some discussion of that a little bit by the panel. Right now, the power company case has been pending in the Second Circuit for almost 2 years, which if it was the Ninth Circuit, you'd say ho-hum. But in the Second Circuit, that is very, very unusual. So we're sort of all waiting to see what happens with that. The Ninth Circuit is in the process of being briefed. Briefing should be completed within about a month, and that will get set for argument within a few months. So number 7, Central Valley Chrysler Jeep, that's a huge category. This is the California case in which the automakers sued California over the regulations that California promulgated to control greenhouse gas emissions from autos. Right now, all of the lawsuits that the automakers have pursued, those have been thrown out, I think primarily in light of Massachusetts versus EPA in part, but the other part of that is that as a procedural matter, those cases are not really ripe anymore because US EPA has denied California's waiver, which is a necessary prerequisite for California to regulate mobile sources. That waiver denial, of course, is subject of a lot of litigation as well, and we expect all kinds of more litigation coming out of that, which may give you a sense of why all the law firms in the nation have global warming units. The next case on the list, Kivalina versus Exxon, I suspect we'll hear something from the panel about this case as well. This is the very latest version of a global warming lawsuit. A village in Alaska, a coastal village that is falling into the ocean as the result of warming temperatures, no longer having ice protection around the coastline, and because of melting permafrost, is actually needs to be moved, and they have a very specific monetary cost to the relocation of that village. That is now in the Northern District of California. They've used a federal common law theory. It will be interesting to see how that proceeds, and I'll leave it to the panel to discuss that a bit. Number 9 on the list, there has been a little bit of litigation in California under the California Environmental Quality Act, which is the baby NEPA in California. The Attorney General's office, my office, has filed 1 case, which then had the result of apparently delaying the state budget for about 60 days, but you know, it would seem like a good idea at the time. And it still seems like a good idea as a side comment. There are a few other CEQA lawsuits that are working their way through the system, and if the panel members don't talk about it, I probably will at the very end. Okay, let me quickly. All right, very effective. Thank you. Okay, so this is just a guess, an educated guess of what we're going to see by way of future litigation. AB 32, of course, is the California umbrella law for global warming, requiring a 30% reduction in greenhouse gas emissions by 2020. But more importantly, from a litigation standpoint, requiring massive regulation of many, many aspects of what we do in California. Just an educated guess, but there might be some litigation over some of that. CEQA almost certainly will give rise to further litigation. Number 3, the Endangered Species Act. Right now, the polar bear listing is months and months overdue. There is a decision requirement timeframe for the federal government on its listing decision of the polar bear. There's a lawsuit about unreasonable delay. My guess is that there will be suits regardless of whether the polar bear is listed or not listed. But the listing of the polar bear will also have major implications for the next stage of litigation because of the requirements of the Endangered Species Act and what that means for government projects. There will be more NEPA suits. I'm expecting that there will be litigation involving requirements for companies to divulge risk. And that's what the SEC disclosure category is. We haven't seen those yet, but I would expect you would. Number 6 is an inevitability that we're looking at trillion-dollar markets for offsets, for emissions. And so you're inevitably going to see market fraud. And it's something that, unfortunately, I have a lot of experience with, having worked on the energy crisis matters. So I think we kind of live with the idea that we're going to see a lot of that litigation. There are other pieces to talk about, but it's way more interesting to hear from our panel. So let me turn it over to Ted Boutros here to start us off.
Thank you, Ken. It's really great to be here. I think there's probably hard to find a more important issue than coming up with smart environmental policy and smart environmental law. And I was saying to Rick earlier that if you look back in time, say 30 years ago and then to today, really environmentalists and environmental lawyers who have been seeking to protect the environment have had, I think, significant positive impact on our country and the world, and have had really significant victories that we sort of take for granted now. When we were here about a year ago talking about the Mass v. EPA case, I think things had changed within the year preceding that, but even since then, there have been, I think, tremendous changes, maybe not so much in the legal world, but in the public debate about global warming. And a lot of that, I think, has been driven by the litigation. And so the topic, I guess, of our panel is what are the potential gains and limitations from litigation relating to global warming. I thought I'd focus on the public nuisance cases, since that's what I know most about, and because I think it's an interesting window into the topic today. I think in terms of the public nuisance litigation, probably the most potential lies not in the ultimate, in any ultimate win for the states. And I think that it's really more, if I gave Ken some truth serum, maybe I could get him to admit this, but that it's really serving more to drive public debate and to drive the public policy that really needs to be established in Congress and in the executive branch. And it's tempting to say, well, that's not an appropriate use of the legal system, but in the United States, we have a tradition, I think, of the courts being used to bring claims that are creative, novel, untested, and to push the legal system, use the legal system to push societal changes and legal changes. And I think and I'm speaking only for myself, not my clients, I think if I were to say, is there some potential benefits that might come from that on one side or the other, I think that the nuisance litigation has affected the debate, and as Ken alluded to it, they're really interesting cases. They're fun. They educate judges and the public when there's reporting about the decisions and written opinions from judges talking about the public policy debate that precludes them from recognizing a tort. And so I think that's the potential upside and gains that can be had from these public nuisance lawsuits. I thought what I would do is talk briefly a little bit more in detail about the individual cases and then give you my bottom line take on this. The first case is what we call the Aep case that Ken alluded to, that the states brought against the utility companies. And boiled down to its essence, the argument was these utility companies are emitting greenhouse gases and they're contributing to global warming. Federal judge, we want you to determine what is an unreasonable amount of emissions, and we want you to establish a standard, and then we want you to issue what's basically a law in the form of an injunction to regulate those emissions. And the key argument, there were a couple of arguments. One, that there's no federal common law of nuisance, and that would cover that kind of claim. I'll come back to that. And then a second theory, which is the one that the judge in Aep accepted to dismiss the case, which was, in his words, that there was a transcendently legislative nature of the litigation, that it was a political question, the proper standard for emissions of greenhouse gases in order to control and minimize and reduce global warming is just a quintessentially economic, political, social, difficult, complex, probably the most complex issue, one of the most complex issues that we'll face. And that's just something that a federal judge is not supposed to resolve, is not equipped to resolve, can't resolve, and so the judge dismissed that case on those grounds. In the California case that Ken and I have been litigating together, the state of California filed an action not seeking injunctive relief, trying a different strategy, one that I think is even more doomed to failure. Again, it's creative, but the theory is we can't get an injunction, so let's seek billions and billions of damages from a different sector of the economy, the automobile companies. And as most of you know, many, probably most right now, of the automobile companies are having somewhat a difficult time surviving and thriving in our changing economy. But only the 6 major automakers were sued by the state of California. And the theory was, again, that they build products that emit carbon dioxide, and that's contributing in a significant way to global warming. And California is being injured by that because of the effects of global warming on California and its land and its people. We argued that raised, again, a quintessential political question. One, damages are a form of regulation. That when you say we're going to impose a large damage award on you, looking retrospectively for not meeting a certain standard of emissions, for emitting too much into the atmosphere, and if you keep doing it, you're going to have to keep paying damages. That's an effort to regulate and to cause the auto companies to build cars that emit less greenhouse gas. And to make that determination, here would have to be a jury because it was a damages claim and the state requested a jury. So we'd have 12 people picked at random who would make global warming policy essentially for the world, because the vehicles emit carbon dioxide not just in California but all over the world, and it's that collective emissions that cause the atmosphere to warm, and that is what is harming California. It's not just the emissions in California. So we argued, and Judge Martin Jenkins, who's now on the California Court of Appeal, agreed with us that that was a political question, again, fraught with complexities that a jury and a judge in a federal litigation couldn't resolve. And just to quote Judge Jenkins briefly, he said, the lawsuit unreasonably encroached into the global warming issues currently under consideration by the political branches, and that these were policy decisions that really had international and national implications. One of our other arguments was that the federal government, as a policy matter, both Congress and several presidents have made the determination that unilateral action by the United States was not the right policy at this time, because it would discourage other countries from coming to the table and really agreeing on an international framework that could really solve the problem, or at least start to solve the problem. So Judge Jenkins dismissed that, and that case is now on appeal. The third case, I think, that sets the framework is this Alaska case. And again, it's seeking damages. It's actually interesting. Again, I think it's not going to fly, but it's a case seeking relocation costs for this village in Alaska. So between $95 and $400 million. The argument is similar, that the oil companies and the utility companies caused a certain level of global warming. They knew they were doing it, and they therefore should be made to pay the relocation costs of this village that is crumbling because of the effects of global warming. That's the allegation. They added another twist, and that's why these cases are, frankly, really interesting to litigate, that my adversaries on these cases come up with new angles. So that in this latest case, the plaintiffs' lawyers argued that it was just like the tobacco cases, that it was a conspiracy, that the oil companies and the utility companies really knew that they were causing global warming, and that they, just like the tobacco companies, they argue, they funded studies and argued that there really wasn't the problem with global warming, and that this conspiracy allegation would, I think that their strategy might get them around the problems that the district judges in Aep and in the General Motors case found required dismissal. I think that's not going to work, because in the federal system, you can't just have a standalone conspiracy claim. It's a conspiracy to engage in a public nuisance that is not a viable claim. So I think that won't survive. This conspiracy allegation raises a whole other set of issues under the First Amendment. That this is a democracy. This is a hot button political issue of public policy. If you start calling people conspirators because they take a different view than you, then our courts would be filled with conspiracy claims and attacks on speech in the political system. So I think that one's not. I wish the village well, obviously, and hopefully there's some other solution, but I don't think a public nuisance case is going to be the way to go. So my view is, in terms of that there are huge limitations from a legal perspective on these global warming nuisance cases. And here's why. First, as I mentioned, these are not legal issues. These are public policy issues, scientific issues, environmental issues, political issues. Second, to deal with the global warming issue, it's a super important issue, but to deal with it, it involves a trade-off between all sorts of different things, cost, utility, and we need to come up with something that will actually have an effect. And I think we'll talk a little bit about whether one state can actually successfully address something that really is the product of activities of people around the world. And so it needs an international solution by policymakers, not by courts. And I think judges will realize that, and judges, my third point is, I think do recognize they're not equipped and they're not supposed to be issuing rulings or having jury verdicts that try to resolve that kind of problem. The other reason that these cases from a legal perspective, I think, are not going to have a significant impact is because they're completely unmanageable. Judge Jenkins noted it. The AEP judge, I think, recognized it. Just to take as an example, both cases involved a claim of joint and several liability. Well, it's undisputed that every one of us in this room, every industry, everybody walking the face of the earth contributes in some way to global warming. So theoretically, to really resolve the case in a fair way, we'd have to implead everybody in the world into the case and then figure out how to allocate damages. California, we argued, contributes massively to global warming. In fact, encourages the use of automobiles, has the biggest fleet of automobiles of anyone in the state, has brochures that encourage people to drive the highways on vacation, you know, pack up your family and drive. How can California collect billions of dollars of damages from the people they bought the vehicles from? I think it's totally unmanageable. It will not work as a claim. So I think if this ever made it to the Supreme Court, it would be a 9-0 win for my side. Just to be modest in my predictions here. People are scared to predict, not me. 9-0 win. So from a legal perspective, not great. But from a public policy perspective, I think there is a positive gain. And just to turn to the Mass v. EPA case before I turn it over to Professor Merrill, again, my clients had argued, some of my clients, that there was no standing to challenge the EPA's authority to regulate greenhouse gases, and that on the merits it was improper. But putting that aside, that use of the legal system obviously was quite beneficial. One, the states prevailed, so clearly it was a good idea to file the suit. It changed the debate. The Supreme Court's opinion talks about global warming as basically as a fact and endorses one side of the scientific debate, I think, to a significant degree, changed the debate, changed the public debate about it. And furthermore, it was another nail in the, why I think it was good, it was another nail in the coffin of the public nuisance suits, because under federal common law, you can't have courts, as probably a lot of you know, there is no general federal common law. It's a really narrow area of lawmaking for the federal courts. And if there's a legislative framework, if there's already a system set up by the policymakers, there can't be a federal common law claim. And in the Mass v. EPA case, the court basically said the sovereign power to deal with global warming issues has been vested in the federal government through the Clean Air Act and other mechanisms. So a big win in that area, I think, for the states in terms of pushing the debate is also a recognition that the states by themselves have very little authority to enact regulations or to engage in tort litigation, tort lawsuits like these nuisance suits to try to deal with the problem. So I think that the process is now in place. It's a political process, and it's a wide open debate with arguments on both sides, and I think that's how these issues should be resolved. But I do think that the public nuisance litigation has driven some of that debate, and hopefully it'll get us to the right solution soon. I think so.
Well, I certainly agree with Ken and also Ted that climate change has reinvigorated environmental law. From the perspective of an environmental law professor, I'm sure Kirsten will agree with me on that point, if nothing else, and has gotten the juices flowing. on the part of both professors and students alike to consider some of these issues. Now, if you're a professor and you're faced with an issue like this, there are one of two things you can do. You can either run along behind people like Ken and Ted and desperately try to keep up with what they're doing, or you can sort of drop out of the race and sort of try to burrow a little deeper into some of the underlying issues and try to get down to a couple of layers below the surface and see if you can sort out some of the things at that level. And I dropped out of the race. I wrote this early article that Ken alluded to before the Aep case was even decided, talking about some of what I thought would be the legal issues, but quickly concluded that I couldn't possibly keep up because things were developing so rapidly. But I have continued to mull over some of the issues. And the thing that I keep coming back to that interests me the most is this idea of public nuisance and the whole concept of what a public nuisance is, because I think it's sort of the linchpin of a lot of this litigation for some of the reasons that Ted described. First of all, several of these cases that are major cases are expressly based on the theory of public nuisance. We haven't had an adjudication yet. We're fighting about whether these cases can go forward, but if some court decides that they go forward, eventually we'll have to try them under theory of public nuisance. The federal common law of nuisance has been mentioned. That's implicated in a number of these suits. If, for some reason, some court decides that some federal common law of nuisance case goes forward, then presumably the federal common law of nuisance would have to be based on the public nuisance idea. And so we'd need to figure out what public nuisance means in order to figure out what the federal common law of nuisance means. And lastly, and here I think I disagree a little bit with Ted about Massachusetts versus EPA. That case, a big victory for the anti-global warming forces. I detect in that case lots of echoes of public nuisance ideas. For example, there's a very interesting passage in the case about why the state of Massachusetts ought to be found to have standing to challenge the government's failure to regulate greenhouse gases more easily than a private person would have standing. And the court's discussion there cited some old public nuisance cases and kind of invokes, at least indirectly, one of the major themes of public nuisance law, which is that the principal legal officer of the state always has standing to raise a public nuisance claim, whereas a private citizen has more difficult time raising a public nuisance claim. And that distinction was carried over into the federal law of standing in Massachusetts versus EPA, and there were these public nuisance cases that were cited in support. So I think the public nuisance idea has also entered into the standing analysis that will apply to any case in which someone is challenging the government's failure to regulate greenhouse gases. So since my time is limited, I want to start by giving you the bottom line, so to speak, on where I'm coming out in thinking about public nuisance, and then I'll try to give a few of the reasons that lead me to reach those conclusions. So I think there are two big issues presented by public nuisance law. One is, what is the duty of care that a defendant is subject to in determining whether or not they have committed a public nuisance, whether they have violated this tort principle of public nuisance law. And the second big issue is who can bring a public nuisance suit, who has the authority to raise a public nuisance argument. And my bottom line, which the lawyers in the audience will immediately perceive to be totally reactionary, is as follows. First, I think that the duty of care ought to be defined exclusively by enacted laws, so that a public nuisance is committed when someone violates a regulatory duty which has been established by a statute or a municipal ordinance or by some administrative regulation. The duty of care should not be established by having the courts sit down and cogitate about whether the costs and benefits of a particular defendant's conduct amount to unreasonable interference with the common rights of the public, to use some of the language of the Restatement of Torts. Second, So I would limit public nuisance cases to essentially regulatory violations. My second bottom line is that the only entities that have authority to bring public nuisance suits are the legal officers of the government. And this would be a question of state law as to who has authority, and it would be the state attorney general almost certainly in most places, but it also could be the state's attorney or the district attorney, depending on how state law defines authority to initiate litigation to protect the public against diffuse harms. But private entities, no matter how severely injured by the conduct alleged to be a public nuisance, ought not to have standing or authority to bring public nuisance suits. So let me offer you a brief sketch of some of the reasoning that leads to these conclusions. It's a kind of mixture of sort of general policy considerations or constitutional policy considerations, but also some history. I think that, interestingly enough, history does not compel my conclusions, but it's not clearly against me either. And so I think at least the history permits these interpretations that I've come up with to a much greater degree than most people would imagine. So, why would I limit the duty of care to the violation of norms that are written down in enacted law passed by some legislative body or by some administrative agency exercising delegated legislative authority? I can think of dozens of reasons for this, but let me just give you four. And Ted alluded to some of these, I think, in his comments.
Four sound good.
Four sounds good. First, there's a separation of powers point here. I would have thought that a completely discretionary determination of what is or is not in the public interest based on a weighing of benefits and costs is a job for the legislature to undertake, not the courts. And if not the legislature, then some administrative agency exercising the powers of a legislative nature delegated by the legislature to the agency. Just to give you one example here, the Supreme Court of the United States, way back in 1803, in a case called Hudson and Goodwin, held that there's no common law of crimes in the federal system, and they cited separation of powers concerns. They said the identification of the kind of conduct that is criminal is something that the legislature, the Congress, is supposed to do, not something that a court can do case by case. The states have never been quite as strict about separation of powers, and we're talking here about civil rather than criminal liability, but I think the same principles carry over, that if we're trying to decide what the public interest means in a very formless, unstructured sort of way, weighing the benefits and costs, that's something the legislature is supposed to do, not the courts. Secondly, democratic theory or democratic principles, and Ted also alluded to this briefly. We're talking about rights common to the public, and it would seem that those rights ought to be determined by the elected representatives of the public, or at least persons who are accountable to the elected representatives of the public. Nuisance disputes often involve sharply conflicting interests. Some of the classic public nuisance suits, which seem quite quaint in light of global warming, would be things like, is a low bridge that cuts off navigability on a river permissible or not? The bridge facilitates people crossing the river, but it blocks people from going up and down the river. How are we going to decide what the public interest is in that situation? Or about a pigsty, which is located in the outskirts of the village, which gives off a stink and makes everybody somewhat uncomfortable, but produces lots of pork for people to eat. How are we going to balance interests in that sort of situation? I would suggest that the resolution of these conflicts will often entail compromise and bargaining among the affected groups, and that's probably a good thing, but it seems to me that legislatures are the proper forum for that bargaining and compromise to take place, not a court of law. Third consideration is just one of general comparative institutional competence. Suppose you don't think that this is all a matter of bargaining and compromise, that there's a single right answer to whether something's a public nuisance or not. Even if that's the case, in order to figure out what the right answer is, we're going to have to find lots of facts, we're going to have to assess these facts, and we're going to have to weigh and balance the facts on either side. These are not adjudicative facts that courts find, like whether or not Smith shot Jones in the alley last week. These are questions about climate science and the welfare effects of increasing global temperatures. These are not the things that you would want to assign the typical state court judge or even federal district court judge to try to figure out, given the tools and the intellectual capacities that the judiciary has. Almost everybody, I think, would acknowledge that it's better for some kind of administrative agency probably to try to solve these things rather than a court. Fourth, I think there's a question of notice. If a state were to pass a statute that made it a criminal offense to commit an unreasonable interference with rights common to the public, and I'm quoting directly from the restatement definition of public nuisance now, that would be struck down as a violation of due process. That language gives absolutely no notice to anyone of what sort of conduct is prohibited. It provides no constraint on public officials in terms of who they prosecute or why, and therefore it raises the specter of arbitrary and unequal enforcement. Obviously, we're not talking about criminal prosecution here, we're talking about civil liability, but I think some of the same concerns apply. California is seeking massive damage judgments from the auto industry under the public nuisance theory. Those damage judgments could be highly devastating to the industry. The Connecticut plaintiffs in the Aep case are seeking very extensive injunctions against the operations of power plants by major utility companies, power plants that were not designed with the thought that restrictions on carbon dioxide emissions were going to be part of the picture, and those injunctions could be extremely disruptive to those corporations as well. And so I think if this were enacted as a law, I think very serious due process concerns would be raised, and I fail to see why having some court announce these restrictions, either as a matter of injunctive or damages relief, gets us out from underneath the notice problem. Fortunately, I think there is a solution to all these problems. We don't have to abandon the law of public nuisance altogether. The restatement of torts as a kind of vestigial element left over from the pre-1970s era has an alternative definition of a public nuisance. It's definition B in section 821B, if you're interested. It says a public nuisance is conduct prescribed by a statute, ordinance, or administrative regulation. So I guess I would suggest that if we adopt that definition of public nuisance and get rid of the definition that it's an unreasonable interference with rights common to the public defined by the balancing of harms and benefits, that we solve the problems that I've alluded to. We would have the definitions established by a legislative body rather than a court. It solves the separation of powers problem, solves the democratic accountability problem, solves the institutional competence problem, and quite likely solves the notice problem that the restatement's approach creates. So that's the first part of where my thinking is headed. The second question, which is equally important, is who has the authority to bring a public nuisance action? Now here everyone agrees that the principal legal officers of the state have authority to bring public nuisance actions, and I don't disagree with that at all. I think public nuisance in this regard can be seen as sort of the civil analog of criminal prosecutions. Of course, the Attorney General, the state's attorney, or the district attorney can bring criminal prosecutions to protect diffuse public interests in safety, health, and welfare. And I don't see any reason why they shouldn't be able to bring injunction actions to stop the same conduct if it's ongoing or repetitious or it's threatened to recur in the future. And this is the classic definition of what a public nuisance is. The tricky question is whether or not private citizens are allowed to bring public nuisance actions. And here the Hornbook law is that a public nuisance suit can be brought either by an officer of the state or by a private citizen, provided the citizen can show special injury from the public nuisance. And special injury is generally defined as injury which is different in kind, not in degree, from the kind of injury experienced by members of the public as a whole. The law review commentary on this point, which I should say is quite extensive, is uniformly hostile to the special injury requirement. The law review authors think that this is unduly restrictive and that essentially we ought to permit anyone who has suffered injury in fact from a public nuisance to have the ability to bring the public nuisance action. Again, I disagree, and I think I could bring out some of the same kind of concerns that I brought out in connection with the duty of care point, separation of powers, democratic accountability, institutional competence type points. I would add here another point, which I think that there is a reason why we no longer permit private citizens to bring criminal prosecutions. At one time you could. About the same time that the public nuisance law was evolving, it was also possible for a private citizen to bring a criminal prosecution against someone. But I think over time we have thought that that's not such a good idea, that it's, that if we're going to bring the full force and authority of the state against somebody and threaten them with criminal sanctions, it's highly desirable that we have a publicly accountable official make the decision whether to bring the prosecution, rather than leaving it up to the whim or the hostility of individual citizens, that this is a kind of screen or a safeguard against arbitrary and oppressive prosecutions. And I think a similar point applies in public nuisance, again in a more attenuated fashion. We're not talking about throwing people in jail, we're just talking about massive damages, liability, and injunctive actions. But I think still, before the force of the state is brought against an individual for violating public rights, diffuse public rights, having this sort of secondary screen by a publicly accountable official make the decision is helpful and is protective of our individual rights and liberties. The main point I want to make, however, in this connection is a conceptual point, not a policy argument. And it's as follows. I think that the whole discussion, at least in the modern era, coming after the second restatement in the 1970s, is based on a conflation of the ideas of cause of action and standing. As the U.S. Supreme Court, at least, has come to understand, both are required before a plaintiff can secure an adjudication in court. The plaintiff has to show that there's a cause of action. The plaintiff also has to show that the plaintiff has standing. Standing refers generally to the type and kind of injury that the plaintiff has sustained. The court says the injury has to be concrete, particularized, redressable, and so on and so forth. Cause of action is different. Cause of action refers to whether or not the plaintiff has a legal right to seek redress in the court. The plaintiff has to show that she has a legal right to X such that if she can prove that the defendant has violated that right, has breached a duty to the plaintiff, that the plaintiff is entitled to relief. I don't have any doubt that most plaintiffs in public nuisance suits, I'll put aside the global warming cases for a moment where I do have some doubts about this, but in a typical public nuisance suit involving a pigsty or a blocking of the river or something like that, I don't have doubt that most of the plaintiffs that bring those suits have shown injury in fact, in the sense that they have some kind of particularized, monetizable perhaps injury, and therefore in a standing sense they ought to have standing to bring the public nuisance action. The real question is, where is the cause of action? The restatement defines a public nuisance as the violation of a right common to the general public. It's the public that has the right, not any particular individual. The restatement never identifies any individual right, the violation of which by the defendant gives rise to a cause of action for redress. Private nuisance is very different. In private nuisance, the individual right is the right to the peaceful use and enjoyment of some particular piece of land that you have a possessory right in. There's a distinct and concrete individual right and a duty that the defendant has not to interfere with that right, but there's no such thing in the public nuisance discussion at all. So I think, to sort of cut to the chase here quickly, is that the special injury requirement really should be interpreted the following way. It should mean that if the plaintiff has suffered some tortious injury, some injury that would independently give rise to an action in tort, that they can bring an action against the defendant for the perpetration of what also would be a public nuisance. So, for example, if the defendant blocks the highway and I can't get to my house, that would be a private nuisance as well as a public nuisance because it interferes with the use and enjoyment of my land. I can't get to my house anymore, and so I could bring a private nuisance suit. That gives me the authority to claim to also adjudicate what amounts to a public nuisance and interference with the public right. Or to use the classic case which gave rise to the private action in public nuisance, if the defendant cuts a ditch across the road and people are forced to detour around the ditch to get down the road, that is an injury common to the public. And if I go up and down the road more than anybody else, I don't have special injury because I just am inconvenienced in the same sort of way that everybody else is. But if my horse falls in the ditch and breaks its leg, I do have the right to bring a tort action, and that's because of the defendant's negligent action causing damage to my horse, to my chattel, in effect, which is an independent tort, and therefore I have the right to seek vindication of this. I'm not completely making this up. It turns out that if you read the introduction to the first restatement of torts in 1936, explaining why they're not including public nuisance in the restatement of torts, the explanation is basically what I've just described to you, that this is a right of the public, not an individual right, and that individuals have rights to bring actions in public nuisance only if they sustain some separate tortious violation. It's also interestingly mentioned very fleetingly in Keaton's 5th edition of Prosser on torts, where Keaton muses that perhaps standing should be limited to private plaintiffs who have suffered independent tortious injury. So anyway, I'm out of time. I do think that this analysis would have certain very distinct implications for a lot of the cases that Ted and Alex have talked about. You can probably figure out those implications for yourself. Some people clearly would not be able to bring public nuisance actions, other people would. And certain claims for public nuisance would be dismissed on the ground that they don't state a violation of underlying enacted law by the state. But in other cases, perhaps after California's AB 32 is implemented, the state would be able to cite specific regulatory provisions that were violated and would be able to bring a public nuisance action. But I'll leave further inquiries for the question period. Thank you.
Well, I was thinking about, while Tom Merrill was talking, where I fit in to this sort of running to catch up versus dropping out of the race. And I think I fit into kind of trying to sort of run alongside. I think, like him, I started out by trying to catch up. But the issues that actually I've been the most interested in state-level climate change regulation is really why are the states acting on this global pollution problem when it's clearly something that international bodies should be dealing with, and the worst case scenario the federal government should be dealing with. So a lot of my thoughts have been trying to figure out why the states are acting, and that's really what I'm going to talk about today, is looking at kind of why the states have been filing these lawsuits, and also what benefit do we get out of it. Because the other issue I'm sort of interested in is how do we kind of make this all work together, and eventually we're all expecting that we will have federal regulation. So I think a big question out there is, what should the states be doing in the future? How do we channel all this energy and interest in global climate change in the future, even in the wake of some kind of federal climate regime? Do we want to use this cooperative federalism approach, or do we want to do other things? What actually taps into what the states can do? Okay, but as I mentioned, I'm going to be talking more about sort of why are the states doing it, and I think I agree with a lot of the more legal points of Tom about some of the problems with these cases, but I'm really not dealing with the legal arguments so much as a little bit more the context. And I conclude, at least with respect to a lot of these cases, is that they are an attempt that really you can't see them without also looking at what states are filing them and what else they are doing, and that they are somewhat sort of complements to what some of the states are trying to do with respect to in-state emissions. And in some senses, they're trying to shift the blame for some of the costs that they are imposing on their own citizens in order to address climate change, and also sort of deal with the defend a sub-global approach to a global environmental problem. And then I want to discuss, because you have to look at, well, if these lawsuits, as Ted mentioned in the beginning, do have a lot of legal hurdles, especially the public nuisance lawsuits. Is there any silver lining here? What are the benefits? What can we say about what they might have to do with getting to something like federal regulation? So first of all, I think everybody can agree what we really need is international, or at worst, what we need national regulation to implement some kind of international agreement. And that state-level regulation of something like climate change emissions, actual emissions, is fraught with a lot of problems. Each state, even a state as large as California, is still a very small proportion of global emissions, and therefore even rather aggressive state action is going to have a pretty negligible impact upon global concentrations of CO2, and the emissions reductions programs put in place by a state is subject to being undercut by the problem of leakage, where emitting activity moves outside the jurisdiction or somehow is switched to areas that are not regulated. This doesn't mean that states do not have a role, even though they do not have, I believe, such a great role in terms of reducing actual emissions. I think states ultimately have a larger role in terms of inducing technological change, which will be a very important part of resolving climate change. I think states really should be looking more into adaptation, dealing with the whole issue of adaptation to climate change, which people are not talking about enough. Okay, but looking at, nevertheless, I think right now, during the sort of interim period before we get any kind of federal regulatory program, even the emissions reductions programs of states is having an important effect, mostly political though. So in the absence of having some kind of federal program, the state that we are in now, I think it's really inevitable that the states are going to try to redress and try to address greenhouse gas emissions. And I think it's also inevitable that the states will initiate litigation in order to really protect the programs that they've put in place. So let me explain that a little bit more. There are a lot of state-level regulatory type programs out there, and many of them do not really promise a whole lot in terms of emissions reductions, or that they're not all that concrete. They're more planning, preparing, analyzing, assessing the idea of addressing climate change. But there are a couple where states really have committed to actual real reductions. They're rare, but they're there, and I think they're rare because precisely of this issue that the benefit that's promised of emissions reductions on a state level, or even a regional grouping of states, is pretty small, and yet they are going to impose some costs on their citizens. But nevertheless, two examples that we were most interested in. One is the regional group of northeastern states, the RGGI program, which is now actually being duplicated out here in the West with the Western Climate Initiative. But under RGGI, which is much further along and is going to go into effect next year, the states have agreed to cap the emissions from greenhouse gas emissions from electric utilities, and then have a tradable, a trading system with permits. There's also California's greenhouse gas emission standards for vehicles that it's trying to get implemented, and of course AB 32. So these are some of the rare but real state programs that trying to actually address real emissions. I think these tort lawsuits offset some of the costs, political costs, and if successful, maybe some of the real, actual emissions gains that could be lost through the problem of leakage. So if you look at the Aep case, the American Electric Power case, all the states that are plaintiffs in the Aep case have committed to making reductions in emissions from their electric power sectors. Many of the states are members of the of RGGI, the Regional Greenhouse Gas Emissions Group. But nevertheless, the RGGI, as I mentioned before, the RGGI is really subject to an enormous threat of being undercut by leakage. The leakage would occur by really as a result of the caps upon emissions within the RGGI states. That's going to open up opportunities for importing cheap power from outside RGGI, which is being produced at much higher emission rates. And the estimates of leakage are from 20 to 40% of the emissions reductions that are promised by RGGI within the RGGI group of states. So not surprisingly, if you look at the defendants, not all of them, but certainly a proportion of the defendants being sued in the Aep case, the 5 largest CO2 emitters in the US are also exporters of power into the RGGI group of states. So you can see this in some ways as sort of a defensive action by RGGI states to make their subglobal approach to emissions reductions more effective by reducing the likelihood of leakage. You can look at California's public nuisance case in somewhat of a similar manner, something of a blame shifting, but also justifying a subglobal approach to emissions, regulating the emissions from the auto industry. California may be imposing the first, it may be the first state to impose carbon dioxide emission standards for cars, but the argument goes, automakers are really the ones that are bringing these global warming emissions. They're the ones that are exporting to California excessive CO2 emitting cars. And they are the real culprits. So it has a tremendous, I think, political value of this lawsuit. And also, by suing for damages, California is showing that that the state is experiencing real climate-related damages, something that will bolster its case for trying to overturn the denial of the waiver of federal preemption under the Clean Air Act that it needs in order to be able to promulgate its auto standards. The Clean Air Act says that EPA can deny California a waiver if California does not meet compelling and extraordinary conditions. California has been making the claim that it is facing compelling and extraordinary conditions just in terms of the tremendous damages that it will sustain from climate change. So those are just 2 examples, I think, of how these lawsuits are really part and parcel of what the sort of subglobal emissions reductions approach that the states are pursuing right now, really because there is such a gap out there in the absence of having the federal government address emissions. But turning now to what are the sort of positive benefits of having the states do this that I think have to be kept in mind. I mean, first, certainly very popular, still prevailing, I'd say, theory of the evolution of federal environmental law was suggested many years ago by E. Donald Elliott and some of his colleagues, that burdensome and inconsistent state regulation of national firms will prompt those same firms to come running to Congress and to lobby for preemptive federal legislation. And I think that we're already, and Ted also alluded to this in his remarks, we're already seeing that dynamic here. Shortly after Aep filed the lawsuit, Synergy, one of the energy company defendants, publicly came out in support of federal climate legislation. Also, more recently, the automakers have supported higher CAFE standards under the Energy Policy Act, a move that automakers were very frank, were saying that they thought that that would help lend justification to EPA denying the waiver to California for its state auto standards. Looking outside the tort context, just at state-level litigation under statutory authority, this panel is generally about climate litigation. Certainly we have the example of Massachusetts versus EPA, state standing. I think that's something of a double-edged sword in that by sort of recognizing perhaps a more lenient standards for standing for states under this Georgia versus Tennessee copper old public nuisance suit that Professor Merrill talked about, there's a little bit of an implication that the standing that's discussed in that case would not apply to private parties if they brought suits under the citizen suit provision of the Clean Air Act. Nevertheless, considering maybe the alternative would be no standing at all, you can see that that state-initiated lawsuit has opened the door, at least for states, to be able to litigate against the federal government, have standing, despite the difficulty of them being able to show, because of the subglobal problem, that that even the federal government's action on climate change would redress the harms from climate change. A final impact, I think, of state-level litigation is kind of this interesting dynamic. It's really a product of some of the way that the laws are written. And maybe my bringing it up is just because I think it's kind of funny, but that state-level litigation can, in some sense, sort of box the federal government into making arguments that will make federal regulation, more likely. And again, this is again turning on this subglobal issue. And an example is EPA's basis for denying California the waiver of preemption for California's car standards. As I mentioned before, EPA can deny that waiver if it finds that California does not have compelling justification. And EPA ended up arguing that there was no compelling justification because really everybody is subject to global warming damages. And California's damages are no worse than what the rest of the country is experiencing and will experience. And so the irony of this is that the plaintiffs in the Massachusetts versus EPA case have jumped on this because the standard under the Clean Air Act for the regulation of auto standards under Section 202 is that in the administrator's judgment, EPA finds that emissions of greenhouse gases from cars is contributing to the endangerment of public health and welfare. So in trying to argue that California did not have a basis for its independent regulation of climate change, EPA seems to be making a pretty persuasive argument that climate change is occurring and actually refers to emissions from motor vehicles as contributing to greenhouse gas concentrations and goes through a litany for pages and pages about how that is presenting risk to human health and the environment. In conclusion, I think really these lawsuits are an inevitable part of the state climate program. It's inevitable in the absence of a federal regulatory program, and it has certain benefits in that I think it will help to hasten along getting us to federal regulation. It certainly does not mean that these lawsuits are necessarily going to be successful. They certainly have a lot of barriers, but I think the real culprit here, if you want to get rid of these lawsuits, and this is what I would say, I guess, to Ted's clients, if you want to get rid of these lawsuits, what you really need to do is to try to get on the bandwagon and try to help Congress reach some kind of consensus on some kind of federal regulatory program.
Some might suggest they are trying to find a consensus,
Yes.
maybe not one we all agree with.
Right.
Well, I want to thank the panel very much, particularly grounding the discussion in theory. I think it's a different approach than a number of panels that I've been a part of. And I think it's very useful to understand kind of in the legal context what, where some of the theory comes from. So, some of us who litigate don't always remember all of that. I do want to, since these guys were kind enough to give me a few minutes to make some responses, to perhaps throw out some somewhat provocative observations and maybe some pragmatic ones, and then leave a few minutes for people if you have questions for any of us. So today, as we sit here, it's fairly astonishing, but in the United States, there is not a single emission control limit of any kind on any greenhouse gas as a greenhouse gas. Now that is slowly going to change because of things like RGGI, but that's the reality. It's kind of amazing given that 5 years ago, one of America's leading scientists on greenhouse gas emissions said we have 10 years to get this under control. So we're not exactly making a lot of progress in Congress. We're not exactly making a lot of progress internationally, and we're not exactly making a lot of progress at the level of the president. So if you're California, and you have 1,000 miles of coastline, and you have 35% of your water supply tied up in the snows that melt sooner in the spring and don't fall as snow so much as they used to, what's a state to do? So here's a little different perspective on litigation by a state, and also the effectiveness of state action. As opposed to having it need to be federal. We filed one lawsuit, the Attorney General's office filed one lawsuit against the county of San Bernardino. And as I mentioned, it was a notorious suit because it got tied up in the budget battles. But that one lawsuit has had along with some other actions that we and some other groups have taken under CEQA, but it has had an absolutely profound impact on what local governments do in terms of decision making. In my 23 years with the AG's office, having done litigation under CEQA for all of that time, this is by far the most dramatic change I've ever seen in a very rapid period. San Bernardino settled a case with us. They agreed to do an evaluation. This was a general plan, a 30-year plan for the development in the county. Didn't discuss global warming emissions, greenhouse gases. In 2006, there were 3 environmental impact reports that mentioned greenhouse gases. One of them was the result of an AG letter. Since then, there have been over 250 EIRs that discuss greenhouse gas emissions and mitigate it. This is a profound change, and the effect of that is gone from California throughout the country with local governments looking at what they can do to address greenhouse gas emissions. This is a truly dramatic impact of a litigation approach, and it's not just litigation, obviously, and as Kirsten said at the end, of course, if you had a federal approach, we would be less in the mode and the mood to pursue it in this way. Now let me talk a little bit about public nuisance, because that seemed to be a little controversial. Remember, we have a tripartite system of government. It's not just the executive, and it's not just Congress. And yes, those are the political branches, but to kind of use an old phrase, the judiciary and the lawyers who participate in it are not potted plants. You're mostly too young to know what that refers to. At any rate, the judiciary obviously gets into social and political issues in the legal context. Civil rights, discrimination, the origins of the environmental movement, all of those were pushed and prompted and prodded by court decisions. Remember that there is a discussion that goes on among branches of government. Just because a court rules that some action is a public nuisance does not foreclose in any manner, unless it's the Supreme Court on a very specific issue that's constitutional in some way, does not foreclose Congress or the executive branch from taking an action in response. And we saw that in the civil rights movement, and we've seen it repeatedly in the history of environmental law and environmental litigation. So this is part of a dialogue, and if Congress doesn't like it, Congress can do something about it. And why should the state of California, which has no redress to Congress at the moment, need to wait for years and years and years as its environment is attacked as the result of global warming? All right, well, I could go on, but I'm sure that there are some responses to that may be of interest. So anybody want to?
I'll jump in. I mean, I think there are a couple things. One, it's true the courts have an important role, obviously, in our system, but usually they're supposed to apply law. And here the problem is we don't have a standard or a law for the courts to apply, and that's the real problem. That if it's such a difficult problem that we haven't hit a solution yet, and I agree with Professor Engel that I think we need a statute, and we need to treat, we need some, this is my personal view, and I think a lot of my clients have the same view. We need some kind of resolution. But without law, juries can't be making these decisions, and it won't really have an effect because of the subglobal problems that Professor Engel was talking about. And there is a standard. I mean, you carefully couched your statement that there wasn't a standard regulating greenhouse gases as greenhouse gases, but the CAFE standards really, short of going to different types of vehicles, when we're talking about vehicles that burn gasoline, the only real way to cut down the greenhouse gas emissions is to improve fuel economy. So we do have standards. So I think, and finally, I do agree with you that there is a tradition of pushing change through litigation, and I do think that it has an effect.
I think one of the most interesting questions that all this presents, and this would be another topic for burrowing down a little bit, and I don't have any pretense of having done this at all, would be, when is it appropriate to use litigation as a catalyst for the political process? When is it okay, or either as a matter of legal ethics or as a matter of prudential long-term political strategy, when is it appropriate to file lawsuits that you don't really have any realistic expectation of prevailing in order to sort of jumpstart the political process and try to get the political process to do something that they're not currently doing? I tend to be a big skeptic about courts myself, maybe too much so, but there are a lot of examples out there of situations where people have filed lawsuits and it's boomeranged, or it hasn't had such a great effect. Massachusetts decided to create a right to gay marriage. Was this a great catalyst, or I think almost 26 states now have passed constitutional provisions forbidding gay marriage after that Massachusetts decision. So maybe that wasn't such a great catalyst. The Monongahela case back in the 1970s was filed to prohibit clear cutting in national forests, and Congress responds by passing a statute permitting clear cutting in national forests. Now, maybe things changed a little bit because of that, but one could say maybe that was not such a great example of progress. Even Brown versus Board of Education, which is usually trotted out as the all-time great catalyst decision, it's sort of the story is sort of ambiguous there. One theory is that this was a great inspiration to everybody to join forces in the civil rights movement and pass the civil rights statutes in the 1960s, which finally did achieve genuine integration. And Brown was sort of the positive, inspiration for all that. Another story is that it so enraged the South that they started beating up civil rights demonstrators and killing them, and then the public reacted to that by passing the Civil Rights Act. So that's, I guess both stories lead to the same conclusion, but it's not, it's sort of a different causal pathway that is somewhat more problematic in the second case than in the first. So I think it's very hard to predict when lawsuits will have a catalytic effect and in what direction they are. The environmental movement seems fixated on the auto story from the 1960s, where California jumped ahead and a few other states jumped ahead, and then the federal government got involved and nationalized auto emission standards, and that seems to be the template that everyone's following with greenhouse gases. But history never repeats itself very neatly here, and so I just raise these questions. I don't have answers to them.
No, I would just say that I was sort of struggling with this as I was coming over here this morning of, does the argument that I was making about these benefits sort of boil down to and ends justify the means. But I'm not sure I agree with that, and maybe we can't get into some of the details of Professor Merrill's presentation about whether or not, what are the parameters of the courts being able to deal with something like this. I mean, there is a history of, in public nuisance, of the courts, dealing with pollution problems before the legislature acted. There's probably more history behind that as well. But whether or not, lawsuits may be for injunctions as opposed to damages, does that really pose as much of a problem? I don't think that these lawsuits pose ethical issues, but probably their, biggest sort of benefit is going to be not in the actual holdings or results, even if one of them maybe wins, but more in terms of pushing the political process forward.
Well, I don't really have time to respond on the merits of my case, but I do think we have a viable legal theory that could win, and it's not just political, although certainly there are political overtones. Let me make one comment, and then if people have questions, come on up and ask them, or go to the microphones and ask. But one thing that Professor Merrill put forward was this idea that a violation of a regulation would be the basis of a public nuisance. That would end public nuisance basically as a concept, because certainly under California law, violation of any regulation, including federal and regulations and local ordinances, is already subject to the authority of the Attorney General to pursue as a violation of something called the Business and Professions Code under California law, and other states have some similar authority. So we really wouldn't need public nuisance if that was the only basis for a public nuisance. At any rate, we've got a few more minutes if anybody has questions, comments. Okay, we put you to sleep. Excellent. Yes, ma'am. Right there, the end of your row.
Thanks for a fascinating discussion. You had mentioned in your introduction the SEC disclosure as an area you saw for future litigation. I'm very interested if the panel might address that matter further.
You want to go ahead? Okay. All right. I guess that's me.
I want to hear what you say.
There are specific requirements under the Securities and Exchange Act, and there are specific requirements under certain state laws for risks that must be disclosed by corporations. And there is a fair amount of thinking and consideration going on right now about what a corporation needs to identify for its investors and for the public and for the government. So, for example, if there are a number of ways that this could come up. For a company that owns property and runs its chip-making operation worth, hundreds of millions of dollars on a coastal plain, what are the risks to the shareholders of that operation going under? as a result of higher sea levels. At what point does it become sufficiently an issue for shareholder concern and public disclosure? That's one way that it arises. And you can also think of it in the reverse fashion, which is that a company that is a mining entity, for example, that is contributing to greenhouse gas emissions through its mining of coal. Well, at what point does its operations leave it open to government regulation and lawsuits and disclosure of impacts that would result in telling the public about the emissions associated with the type of work it's doing? So that's on its way, is my guess. Yes.
Yes. I'm Guido Franco with the California Energy Commission. The state, hopefully soon, will start working also on adaptation because, I mean, it's a complementary action that the state needs to take because climate change is inevitable. My question is, I mean, I think there are some laws and regulations that will impede adaptation. I mean, for example, there is a study that the Energy Commission funded in 2001 that came out with a recommendation that one way to cope with climate change could be to use our underground reservoirs as storage. But the problem is, it is my understanding that if a local water agency wants to store water underground, and another water agency can say that that's not a beneficial use of the water, and therefore, claim rights to that water. Actually, I read that in our local newspaper that this is the actual case. A local water agency trying to do the right thing and being impeded to do that because another water agency was going to claim the right to that water. So, I mean, I think it's just a tip of the iceberg. There are going to be a lot of cases like that when existing law will impede effective adaptation.
Yeah, I think that first of all, and I think Kirsten mentioned the need to move to looking at adaptation issues more extensively is inevitable. I think that's absolutely essential, and no more so than in water, which we heard about earlier this morning as well. But the result of that are going to be endless more lawsuits as your relationship of local governments and local entities and local claims to water are going to change. And I don't know if Michael Hanneman's going to talk about that later today or not, but that's certainly an area that he's spent a lot of time looking at.
All right, please join me in thanking our panel for an excellent discussion.